The individuals depicted have been arrested but not convicted at the time of story postings. This information does not infer or imply guilt of any actions or activity other than their arrest. We make no warranty or guarantee as to the accuracy of this data.
Female companion.
Oh, hello there. Bang a gavel. Welcome one and all. Have a seat. Have a seat. It is time for something we haven't done in a very long time. When I say we, I've got a mouse in my pocket. Mikey the Legend here. This is We Got a Case Live, where we have some cases that we pulled aside. These are from the great state of New Jersey. We'll go ahead and kick on into it. The judge is going ahead and helping us out by reading off the charges for this young feller sitting here in the jail. So we'd love to hear from you. Say hello in the comments, wouldn't you? Get on.
A female companion, both of whom were read their Miranda rights. Upon a search of the residence, the troopers located approximately 21 pounds of marijuana, and the defendant took ownership
21 pounds? Holy crap.
of all of the items. It was also noted that within the 29 grams of marijuana, there was also packaging material, as well as 128 individual packages that were labeled 3 to 5 grams, indicating that this was, in fact, marijuana with intent to distribute. The fact that there is these packaging materials and the relatively low standard that is associated with probable cause, I do find for purposes of today's hearing, probable cause has been met, recognizing Mr. Neal's arguments that those facts may go to the weakness of the first degree offense, but nonetheless, I do find that it satisfies at least the relatively low standard for probable cause. With that, I will hear from the state with regard to the grounds for detention.
I mean, 21 pounds. That's more than personal use, right? I mean, I've never used the grass, the Mary Jane, devil's lettuce, none of that, but that's a lot. Speaking of a lot, there's 19 months a member. Thank you. If you're new here, guys, we appreciate our members. We appreciate our chat, so we thank them when they do amazing things like that. Thank you, Bob.
Thank you, Your Honor. This defendant scores a 4 for failure to appear and a 5 for new criminal activity on the PSA, which recommends release with weekly reporting. The state, however, did file for detention. At the time of the commission of this offense, the defendant had a pending charge for a 3rd-degree domestic violence-related aggravated assault out of this county, and he was placed on level 1 monitoring for that offense. The defendant also has 2 prior disorderly persons convictions out of Delaware, one of which is for fraud, and the other of which is for assault. The defendant also has 1 prior indictable conviction for 2nd-degree unlawful possession of a handgun, and he was sentenced to 5 years imprisonment for that offense on December 1st, 2017. This defendant additionally has 1 prior failure to appear, which is older than 2 years, and he additionally has 1 active temporary restraining order that was entered against him. The state has concerns if this defendant were to be released due to concerns for the safety of the community, as these are distribution offenses, which can increase the risk of crime as there is no regulation, and this is an illegal operation, which poses the risk of additional offenses or the facility itself being targeted for offenses. It's the state's position there's no monetary or combination of conditions that can ensure the safety of the community. The state therefore respectfully requests that Your Honor detain this defendant pending trial. And with that, the state submits. Thank you.
So with a lot of these hearings you'll see come through here in New Jersey, they're basically just trying to make sure they don't get out. They want these people to stay in until their trial for one reason or the other. Think they're going to run, think they're not going to show up, whatever. So those are all pretty big right there. And speaking of being big, that's Bob. That's Bob right there. Bob got hit by a car. F Toyota. Also, Chaos AD. We got some cases. Will we let this guy out? Who knows? Anything's possible, I guess. Robert Michaud taking a stand against crime. Thank you, Mr. Michaud, for that fine $2. Let's find out if we're going to let this fine gentleman out.
Thank you, Mr. Neal.
Yes, Ron. My client has a full-time job at a warehouse in Violent. That's one. Two, if my client does have a pending charge, I anticipate it's going to be remanded and or dismissed, and he does not have any failure to appear. That goes directly to the heart of bail reform. In essence, want to make sure an individual appears in court. This is not a violent offense. Again, I argue in reference to the first degree, and the independent PSA indicates that my client should be released. What we have here, and again, there is, there's going to be room to argue in reference to even the distribution offense, but we have a 4th degree marijuana, and there is no weapons, there is no other aggravating factors that's associated with this offense. When you take that in totality, again, the issue is whether or not there are conditions that can assure the triad. And he lives in Cumberland County. He's tied to Cumberland County. He was on PSA 1, and he did everything he needed to do while on PSA 1 outside of these charges for the marijuana. So respectfully, Your Honor, do the full-time job, do the other variables, and again, the independent PSA and no aggravated factors. We ask that my client is released because we believe there are conditions that can be imposed on my client to, in essence, make sure that the triad is adhered to and addressed. Thank you.
All right.
I love that his first thing he started with full-time job, not just selling weed, full-time job. And he also goes on to say, well, this guy's been doing great, Judge. He's top tier in his community, other than these poundages of marijuana he's got here. So, maybe we cut him a break. Doubtful, but maybe. 20 months a member. 32 months a member. That's a long time. It's almost 3 years, 4 years? I don't know. I love having these I turn real Southern, having these cases that we can go through together. And if you're new, hey, say hello. We know somebody's not Brandy. That is almost 3 years. Exactly what I was thinking as well. Let's find out if we're going to let this young businessman hit the streets.
This is State's motion to detain Christopher Patrick. The defendant scores a 4 for failure to appear and a 5 for new criminal activity. The PSA recommends release on weekly reporting. The defendant is 31 years old. He does have a pending charge for aggravated assault. As Mr. Neal points out, he does not have any failures to appear for that case, which is significant, which means this individual is able to show up for court. I also note he has 1 failure to appear that's older than 2 years. He does have 2 prior disorderly persons offenses and 1 prior unlawful possession of a weapon offense. They are actually both somewhat dated. They are both, the DPs are from 2017. The indictable was from 2015. He did serve a period of incarceration of 5 years in 2017. But again,
5 years?
The defendant has, for the most part, been a law-abiding citizen since those convictions back in 2015 and 2017. He is gainfully employed, and again, the defendant has demonstrated that he does show up for court. And
come on, Judge.
The PSA does recommend release with conditions on level 3 monitoring. So I do find that based on that, that is the appropriate recommendation. So what that means, Mr. Patrick, is I'm going to release you on level 3 monitoring. You are to follow the following conditions. If you violate any of these conditions, the state moves to revoke your release, and that may be granted. So you are to call pretrial services within 24 hours of your release. Their telephone number will be on my release order. Additionally, you are to report to them on a weekly basis throughout the remainder of the time that your case is pending. That some of that will be virtual, some of that will be in person. They will work that out with you when you call them. Additionally, you are not to commit any new federal, state, or local offenses. So that includes, as I indicated, local offenses. So even a municipal violation may result in a violation of your conditions, and the state may move to revoke your release. Additionally, you are not to possess any firearm, destructive device, or any other dangerous weapon. You are to refrain from the excessive use of alcohol or any use of controlled dangerous substance unless prescribed by a doctor. Additionally, you are to appear for all of your court appearances. Your next court appearance will be with Judge Chiarello here in the Cumberland County Courthouse on April 23rd for a pre-indictment conference. And is the state seeking any other conditions of release on Mr. Patrick?
No, Your Honor.
All right. And I didn't indicate on the record, but the one thing that I also
My man was sweating it. He was, this dude's great. He's like, oh dear Lord. I don't know what I was going to do if I had to stay here. That's a lot of weed. If it had been anything other than weed, I think it may have been a different story. I really do. I think they'd buried him under jail. Like, been 4 pounds of heroin or something like that, then been different. But I think the way people look at weed has really changed. Marijuana's still has a stigma in a lot of places, but not as bad as it was years ago. Head coming in, giving the gift over here on. We got a case, Court Watch, and I saw there was a question about a case that was up earlier and taken down. It was taken down, but for some reason, YouTube put it up twice. No idea why. It put it up twice, so it had to be taken back down. Not our thing. It was a YouTube thing. I saw somebody said we were an AI channel. Man, if I was AI, I'd be a lot better looking than this.
Felt significant was, in fact, that the defendant did take ownership of the items. I know that can also go to the strength of the state's case, but it also goes to the fact that the defendant is not a risk of obstructing. So with that, sir, I think there's all the reasons to be released. Mr. Neal, did you want to say anything to your client before I release them?
As soon as you get home, give me a call so I can make sure that you understand the conditions.
Okay, thank you, Mr.
As soon
Neal.
as you get home, give me a call. We'll go out for a
All
drink.
right, sir, if you could have the officers, you are free to step out of the booth. If you could have the officers bring in Navon Bell, please.
All right, thank you, Your Honor.
Bring in Navon Bell, everybody. Are y'all shocked? I'm really not. I'm really not shocked about that. Again, I see it over and over again. People getting less and less sentences on those weed charges. Also, okay, so I got it wrong. It was a Nissan, but I got you to send $5 more, Bob. Thank you. And another 2 bones. The Michaud. Thank you there, Robert. On to our next client.
I'm literally
Seems like a nice guy.
Good morning.
Morning.
Good morning, sir. What's your name?
Navon Bell.
All right, very good. All right, next matter this morning is State versus Navon Bell. This is complaint warrants 2026-215-0601, W2026-810601, and 2025-1518-0614. Counsel, your appearances for the record, please.
Thank you, Your Honor. Candace Burnett on behalf of the state.
Good morning, Your Honor. Genevieve Lamont on behalf of Navon Bell.
All right, are we ready to proceed on Mr. Bell's matter this morning?
Yes, Your Honor.
Yes, Your Honor.
All right, very good. Is the state seeking to introduce any exhibits?
Yes, Your Honor. The state will be relying upon pre-marked exhibits for purposes of today's hearing. They are S1 complaint warrant number 2026-215-0601, S2 the PSA generated on February 26, 2026 at 9:56 a.m., S3 the pretrial violation monitoring report dated February 26, 2026 at 9:26 a.m., and S4 the pretrial violation monitoring report dated January 20th, 2026 at 12:35 p.m. If the defense has no objections, the state would like to move these documents into evidence.
No objections, Your Honor.
All right, very good. With that, I will hear from the state on the facts.
Thank you, Your Honor. On the warrant ending in 215, the defendant is charged with disorderly persons domestic violence related simple assault.
Oh, piece of
The
shit.
events giving rise to this charge occurred on February 15th, 2026. On that date, Bridgeton troopers were dispatched to the area of Evergreen Estates in reference to a domestic related incident. Upon arrival, troopers spoke with the victim, who advised that she and the defendant got into an argument. The victim reported that during the argument, the defendant struck her in the head several times, which caused visible signs of injury to the victim's face and upper lip, specifically swelling, bruising, and a minor laceration to the victim's upper lip. And with that, the state will submit on probable cause. Thank you, Your Honor.
Smart.
Your Honor, probable cause is a relatively low standard. For purposes of this hearing only, we would move to the detention portion of this hearing and have no arguments in regards to probable
All right,
cause.
probable cause is a relatively low standard. It is a well-grounded suspicion that the defendant committed the offense as alleged. Here, the officers did respond to a domestic incident and observed signs of injury to the victim that was consistent with her version of what happened. Specifically, they saw injury to the victim's face and upper lip, causing swelling, bruising, and a laceration to her face. So I do find, for purposes of today's hearing, that has been met. So with that, I will hear from the state with regard to the grounds for detention and to revoke release on the prior matters.
Remember, he's already in trouble. He's already on, he's out right now after some other charges. So it's not like he's now piled them up. We're going to keep this one. We're going to let this one fly. We'll see. Yeah, he's got some beautiful tats on his face. Very nice. 10 man. Thank you. And of course, the non-AI Bob. Thank you, sir. Don't worry. I'm as real as they get. As real as they get.
Thank you, Your Honor. The defendant scores a 5 for failure to appear and a 6 for new criminal activity on the PSA, which recommends no release and contains a new violent criminal activity flag indicating an elevated risk of violence. At the time of the commission of this present offense, the defendant had 5 pending charges which were incurred on 3 separate dates, and 4 of which consist of domestic violence-related offenses, specifically terroristic threats, criminal mischief, and simple assault. The defendant has 1 prior disorderly persons conviction for hindering due to providing false information. He also has 3 prior indictable convictions, 1 of which is for the violent offense of second-degree robbery, and another of which is for domestic violence-related third-degree witness tampering. The defendant has a total of 4 failures to appear, the most recent occurring on December 18th, 2025. He also has 3 failures to appear that are older than 2 years. His PSA also indicates that he has 3 prior sentences to incarceration for a period of 14 days or more. His most recent sentence to incarceration was on February 2nd, 2018, and he was sentenced to 5 years prison for second-degree robbery. He was additionally sentenced on November 3rd, 2017 to 4 years prison for third-degree witness tampering and third-degree receiving stolen property. This defendant also has an extensive history of 13 domestic violence restraining orders, which have been entered against him. 11 of those 13 restraining orders are from this past year alone.
What? 13. That's 1 in a 3. Restraining orders. 11 of those in the past 12 months. Are you shitting me? And this guy walks the streets with normal folks like Bob that only has 1 leg right now. But that's all right. Bob's going to have his other leg working good soon. Thank you for the happy birthday wishes. I'm looking forward to enjoying yet another trip around the sun tomorrow. Thank you, Bob. You're too good to me today, Bob. Too good. Oh, speaking of being good, look at that. That's 10 people. Join us tonight. And I'm going to spoil you guys and let you know something. There will be a new members only opener tonight, debuting tonight on the show. The old one's retired. The new one's coming in, doing the Lord's work. 10 more people. Join us for free, by the way, for a whole entire month. Entire back catalog is at your fingers. Enjoy it, my friend. Thank you. 10. That's huge. It's huge. Just like this guy's charges, for God's sakes.
And though 11 of the restraining orders have since been dismissed, 1 remains an active final restraining order, and another remains an active temporary restraining order.
Same person.
Which is
Can I resolve this? Can I resolve this matter today? I will plead guilty or whatever. This is.
Hold on, Mr. Bell. Hold on. Let us.
I want to resolve. Can I plead? I want to resolve this today. This whole matter, but this is bull. I'm not even guilty for the last one.
Hold on, Mr. Bell. Hold on.
Bullshit, right? I'm not about to be saying this is crazy.
Well said, Mr. Asshole. I think it's kind of telling that's the same person. So many times we see the victim be pressured into dropping the charges or not cooperating. And it seems like that's where we're in a vicious cycle that is going to end up with somebody, unfortunately, probably somebody unalived.
Further, the restraining orders entered against the defendant involve 7 different victims. Additionally, as indicated in the PSA, this defendant was on level 3 pretrial monitoring out of this county on 2 separate matters at the time of the commission of this present offense. This defendant was placed on level 3 pretrial monitoring for his case under warrant number 2025-0015180614 on October 14th, 2025. As part of his release conditions, the defendant was to not commit any new offenses. He was charged with domestic violence-related simple assault, domestic violence-related 4th-degree criminal mischief, and 3rd-degree terroristic threats on January 19, 2026. On January 20th, 2026, the defendant's PSA score was a 5.6 and recommended no release. A detention motion was filed but later withdrawn. The state was released on level 3 monitoring for these additional offenses on January 28th, 2026. Per the defendant's release conditions, he was to appear for all scheduled court proceedings. The defendant failed to appear for a scheduled court proceeding at the Vineland Municipal Court on February 3rd, 2026. And the defendant was also ordered to refrain from committing any new offenses. He then incurred this present offense, which is violent in nature and is domestic violence related, while he was on pretrial monitoring. The state has serious concerns for the safety of this particular victim, as well as the community if this defendant were to be released. As indicated earlier, this is a domestic violence related incident. And as the defendant's PSA reflects, he has a history of domestic violence related incidents, which involves several different victims. This is the second domestic violence offense the defendant has been charged with since initially being placed on level 3 monitoring on October 14th, 2025. The state also has concerns this defendant will not appear for court when scheduled, as in addition to the 4 failures to appear reflected in the defendant's PSA, he also failed to appear for a recent municipal court hearing scheduled for February 3rd of this year. This defendant is already on the highest level of monitoring. It is the state's position there is no monetary, non-monetary, or combination of conditions that can ensure the defendant will not commit any new offenses or guarantee his appearance for court. The state therefore respectfully requests your honor follow the recommendation of the PSA and detain the defendant on the warrant ending in 215 and release his revoke on the warrants ending in 81 and 1518. And with that, the state submits. Thank you, your honor.
Gotta keep this one. If we let this one walk, what are we doing? He's already on the highest level we can put him on. I mean, there's nothing else we can do to monitor this guy, and he's still out beating on these women that are in his life. Apparently, he claims, he says there's one victim. They say 8 or 7, whatever that number is. It's too high. Bob, were you on a bicycle when you got hurt? Yeah, it's a sad state of affairs. Do not stay in those kinds of relationships, guys. Get the hell out. There's no reason to stay, even if there's children. No matter what it is, you'll find a way to figure it out. Promise you, there's so many services out there to help people. Keep an eye out for those. And if you know somebody that's in that kind of situation, please reach out to them. Sometimes all it takes is just a helping hand to move it along. Speaking of helping hands, 5. That's a whole hand's worth right there. 5 more people joining us. That's 15 right there. Last 2, was it 16? Well, 16 new members just today. I love it. Let's get on back to this fine, upstanding gentleman.
Thank you, Mr. Pratt. Mr. Lamont?
Yes, thank you, Your Honor. Your Honor, I would like to begin by speaking about the extensive history that the state raised. He does have one active final restraining order from 2016, and he does have a temporary restraining order, I believe, that was generated from this incident. But what is significant, Your Honor, and I ask you to consider and weigh heavily, Mr. Bell, you got to let me finish, okay? What I would ask that you weigh heavily is that nowhere in his
he's like a rabid dog.
Is any sort of contempt or violation of any sort of restraining order. So when the court tells Mr. Bell he can't talk to someone, that he needs to stay away from somebody, he does. And so, Your Honor, I would submit that is significant to alleviate any concerns the state has.
There's a lot of people feel that way
regarding the safety of this alleged victim, is that a no contact order and the temporary restraining order seems to, from his history, provide protections and alleviate those concerns. He doesn't violate those restraining orders. He stays away. Mr. Bell doesn't live with this complaining witness. He lives with his father and his son. So there's no shared residence that would complicate an ability for him to stay away and to have no contact with this person. And so just given that, and given that this case has already been remanded, I would ask that you consider that significantly in releasing Mr. Bell from today and release him back on level 3. I understand he only has one prior violent conviction that was over 10
that was
years
weird
old, or almost 10 years old. It was back in 2016. He has not a significant amount of failures to appear, Your Honor. I would submit that the score of a 5 is somewhat inflated. He has 1 from in the last 2 years for a municipal court hearing. But the other three are rather dated. They're from 2016 and 2015. So not only were they issued on summonses, but they were also predate the CJR. And so you wouldn't have been received the benefit of pretrial monitoring. And so, Your Honor, in terms of that, I would submit that his failure to appear score is somewhat inflated, and that I would submit that he has indicated, at least during this hearing, that he wants to get this resolved today. So he wants to have this resolved, understanding that that's not possible today, but he has indicated, at least before Your Honor, that he wants to resolve these cases. He wants to come to court. He wants to make sure that he can move forward and have these resolved. And so, Your Honor, in terms of the concern the state has raised about Mr. Bell coming to court, at least from his representations today, it seems like that's not really an issue. He wants to resolve this. He wants to move forward. Just by way of personal background, Your Honor, he is working. He works with his uncle part-time. He works at U-Haul with his uncle part-time. He has 4 children, 15, 9, 3, and 3 months that he provides for. So
4 children on
he's
part-time
been
job.
in Cumberland County most of his life. Like I said, he lives with his father and his son. He's been at that address for 4 years. So he has stable housing. He has ties to the community. So he's not a flight risk. He's not going anywhere. Your Honor, I would say, just given that there is already a temporary restraining order, Your Honor can impose a no contact order. His history does indicate that he does follow those orders from courts to stay away from people he's told to stay away from. That a no contact would in fact alleviate any sort of concerns the state might have regarding the safety of this alleged victim. He's working. He wants to come to court. He wants to resolve this. He wants to move forward. So, Your Honor, just given that it's also already been remanded, I would ask that he be released back on level 3, given an opportunity to continue working and to resolve these cases and his other pending cases as well.
You can put me on ankle
Your Honor, I
monitor.
would submit.
Anything. Like, I'll take an ankle monitor. Whatever, so y'all know I'm coming to court. Like,
All right.
I don't violate restraining orders or nothing. Like,
This is the state's motion to
And
detain
most of all
Navon
them-
Bell. Just for the record, indicate Mr. Bell has continued throughout this proceeding to interrupt both the state, his own attorney, and now the court.
There you go, Judge.
Just so the record is clear with regard to that. The defendant scores a 5 for failure to appear and a 6 for new criminal activity. There is a no release recommended due to his elevated risk score and elevated risk of violence based on, again, this is now the 3rd offense. He does have the 2 pending charges, which the state has filed a motion to revoke his release on due to the violations of monitoring, which are for the defendant's continued incurring new charges. Specifically, he has, at the time of this offense, he has 5 pending charges from 3 different dates. They do include 2 for terroristic threats, 2 for criminal mischief, and 1 for simple assault. 4 of these offenses are DV related, as the state points out. He has 1 prior conviction for hindering, which is dated. It was from 2015, and he has prior indictable convictions, 3. And they are from 2016 and 2017. But the troubling thing here is that the defendant does in fact have 13 restraining orders, 11 from last year alone. And he was already placed on level 3 monitoring
13.
for domestic violence charges, and he continues to incur these domestic violence offenses. While I appreciate that the case has been remanded, nonetheless, this defendant continues to incur these charges. And here you have a situation where the officers specifically observed visible signs of injury on the victim consistent with what she indicated happened here. So while I recognize Ms. Lamont's argument that the defendant does not have any contempt of domestic violence restraining orders, that he follows these restraining orders, but he still is managing to incur DV-related offenses despite already being on level 3 monitoring, which I note is the highest level of monitoring. And by doing so, he is incurring new offenses. They are, again, domestic violence
Thank you, Marty.
in nature, and he has already failed to appear on one of his matters from this year. and we're only into March. So the defendant has demonstrated that he is not willing to show up for court. He continues to incur domestic violence related offenses.
Keep it going.
I do find that the state has met its burden by clear and convincing evidence that there was no amount of bail or non-monetary condition that will ensure the defendant's appearance in court when required will protect the safety of the victim and our community, because again, this it appears to be a pattern of domestic violence behavior, and that the defendant will not obstruct or attempt to obstruct the criminal justice process as demonstrated by the defendant's continued interruptions of the court proceeding today. So I'm granting the state's motion. You do have 7 days to appeal my decision, sir. Ms. Lamont, did you want to say anything to your client before I excused him?
Yeah, bye, bitch.
Mr. Bell, just hold on. You're going to have a court hearing soon to resolve this matter. Just don't talk about the case with anybody while you're in there. Okay?
When is soon? When is soon? And did it? And
March
then we all know
10th.
that. Okay, ma'am. 10 of them, 13 of them are talking about from the same person, my baby mother, who drops them every single time.
Mr. Bell, that's not helping you, to be quite frank.
I'm just saying, ma'am, when can I speak to you, Ms. Lamont? I want to get all this resolved in court. I want to plea out, whatever. I don't want to keep going back to court for this stuff. She plays the same game and she does. I got messages.
Mr. Bell,
My father have a restraining order on this girl.
Okay, so Mr. Bell, you're going to resolve it March 10th, okay?
Some bullshit, man.
Well said,
This
Mr. Bell.
This is bullshit. It's the same person who keep playing the same games. She keep putting them on me, throwing them out, putting them on me, throwing them out. I got messages and proof that she's saying that she's lying and throwing them out. My father got a restraining order on this girl for doing it. Like she keep doing the same thing, lying, throwing out, lying. Yeah. From the same person, Abigail Elliott. It's my baby
Mr. Bell, all that's going to get resolved March 10th, okay? You just have to hold on until then, okay?
Yeah, I need to talk. I need to get this resolved. Like, this is crazy. I want to plea out and get all this done so I can move on with my life.
Wow.
All right, Ms. Bird, you're free to sit on the booth.
Sounds like a great strategy. Well, you slammed that door right in our faces. Dawn, I'm going to say thank you for the PP. In my hurry to get out here into the studio, I left my phone in the other room. I trust Dawn has been a trusted member of this family for over 10 months. Dawn, thank you for the PP. I will be adding you. And thank you, Dawn, for the PP. If you're looking to send some PayPal or Cash App, I'm sure one of the nice mods will let you know how to do that. We appreciate all the donations and things that go to the channel. Keep it rolling. On to our next case.
All right, thank you, everyone. See you tomorrow.
Thank you.
Going to a new judge.
And with that, defense counsel, do you have any exhibits that you wish to present for today's hearing?
We do not.
And does your client challenge probable cause?
No challenge, Judge.
Although there appears to be no challenge to probable cause, state if you could please set forth a recitation of the alleged facts for the court to consider.
Thank you. On Saturday, February 28th, 2026 at 03:20 hours, member of the Atlantic City Police Department responded to the Tropicana Casino Hotel regarding an assault inside of the marketplace.
In the casino.
Officers were able to speak with both parties who remained on scene. It was learned that Jermaine W. Goulsby had assaulted a patron in the area of the marketplace. A special complaint was later completed against Goulsby for this assault. While I was speaking to Goulsby regarding this incident, he began to walk away and scream within the marketplace.
Thank you, Don. I
attempted
appreciate
to gather
it.
further information regarding the assault, to which Goulsby admitted committing the assault. Goulsby's behavior changed, now flailing his arms and buffing out his chest as he continuously screamed. Due to Goulsby's continuous behavior change, he was physically detained in police handcuffs and escorted to a Tropicana holding cell prior to completing his special complaint form on scene. As I attempted to speak to Goulsby again, he repeated to yell that he was being targeted by police and spit bodily fluids on police.
Oh.
He was informed that he was now under arrest for spitting on Officer
Nasty bastard.
W. Lungus Gonzalez. I was later informed that Goulsby had opened an extra 24 fluid ounces an alcoholic beverage and was unable to make payment after consuming the beverage.
Thank you.
Yeah.
Probable cause is a relatively low standard. Probable cause is a well-grounded suspicion that a crime has been committed and that the defendant committed the crime. With respect to the issue of probable cause in this case, we're having considered no challenge from the defense, as well as having carefully considered the preliminary law enforcement incident report and affidavit of probable cause attached to the complaint warrant, along with the recitation of the alleged facts placed on the record by the state. The court finds and concludes that the state has established probable cause in this matter, that this defendant is an eligible defendant and he committed the charged offenses. Specifically, there's reason to believe that on or about the 28th of February, 2026, the defendant, Mr. Goulsby, committed the third-degree offense of aggravated assault, a violent charge, and the disorderly persons offense of theft of services of items valued at less than $200. Court finds, based upon its review, that probable cause is found for those two charges to issue. I'll now hear from the state on the issue of detention.
Thank you, Your Honor. The state is asking for detention in this case. He is charged with two new offenses: aggravated assault, significant bodily injury, and theft of services. As stated, Your Honor, in probable cause, the defendant did admit to what he was doing. So I'd suggest that the proofs are significantly high in this case. The evidence is significant. And he also admitted, per the reports that were turned over, not only that he did indeed strike the victim, but that he was drunk at the time of this offense. In direct violation, I would suggest, of his pretrial monitoring that he's currently on level 2 out of this county. This again occurred on February, I believe 28th, as stated earlier. The defendant was placed, it looks like, on pretrial monitoring out of this county in 2026 for the charges of possession, burglary, and criminal mischief. Those arrest dates and offense dates are from November of 2025 and January 12th, 2026. So this defendant just was placed on pretrial monitoring, and now here we are again in front of the court with brand new charges, aggravated assault and theft, and the defendant admitting not only to being drunk, but also to committing the assault. This is obviously concerning to the state in that he is not following court orders, and within just a month or so of being placed on pretrial monitoring. The recommendation of the PSA is no release because of these repeated arrests while on pretrial release. He did score a 2 for failure to appear and a 3 for new criminal activity. I would suggest also that he did have a domestic violence restraining order. It has been dismissed, but it appears that the restraining order was issued in January of 2026, and the underlying acts were harassment, cyber harassment, assault, criminal mischief, and terroristic threats. There is an out-of-state conviction from 2025 on his PSA. Your Honor, the state believes that based off of all of this, that there is no monetary conditions, non-monetary, or combination thereof that would assure his appearance in court, that he wouldn't obstruct the process. He's already on level 2 out of this county and has not remained law-abiding. He does appear to be a danger to the community based off this continuous behavior. He's clearly in violation of his monitoring by obtaining new charges and consuming alcohol. And we do believe he's a poor candidate for pretrial release, and we would ask that Your Honor detain him based off of these new charges.
We'll now hear from the defense.
Judge, Mr. Goulsby is before Your Honor with his most serious charge here being this 3rd-degree assault. So there is no presumption of detention or imprisonment here. His other charge, as Your Honor noted, is a disorderly person's theft, and that is for allegedly drinking a beer without paying for it. He scores a 2 and a 3. He does have 3 pending charges that look to be from 2 separate incidents. 2 of those charges are disorderly persons offenses. His most serious charge that is pending is a burglary charge. My understanding of that is that involved a girlfriend who has advised the prosecutor's office she does not want to proceed. So Mr. Goulsby is hopeful that case will ultimately end up in a dismissal. He has no prior disorderly persons convictions. He has no prior indictable convictions, so he is PTI eligible. He has never failed to appear for court, and he has never been sentenced to any term of incarceration. As for the nature and circumstances of this offense, this allegedly occurred at 3 a.m. at the Tropicana. I think it's probably clear from what we've seen that intoxication was involved. Mr. Goulsby is certainly very remorseful and regrets everything that happened in this incident. There appears to be alcohol issues involved with Mr. Goulsby, which he is wanting to address. He is very young. He is only 23 years old. He has quite a bit of family support. He lives with his mother.
For anybody getting here, anybody wondering, we are in New Jersey, the Garden State. Is that right? Guys in truck, Garden State. And obviously the crime state.
Locally in Atlantic County. He was raised by his mom, who was a single mom who worked three jobs to support Mr. Goulsby. His mom's employer has even reached out to us to just give us a little background on his family and just stress the family support that he has and the obstacles that he's overcome. His father is an alcoholic, and Mr. Goulsby is certainly struggling with that right now. I think he's certainly at a crossroads in his life, having never been in jail before and now being in jail for almost a week. I think he's learned a pretty harsh lesson, and I know he wants to get help for himself. He is not currently working, but he is actively looking for work. He was in the military. He was recently discharged again for issues with alcohol, which he was getting treatment while he was in the military and unable to complete that treatment because he was ultimately discharged. I don't think he's at risk of failing to appear. There is certainly nothing in his background that would suggest that. Not a risk to obstruct the process. He's not going to do anything obstructionist, despite the allegations here. He's certainly not a danger to the community, to anyone. And I would guess that this case would likely end up, hopefully in PTI at worst, but certainly I can't imagine that he'd be facing any substantial term of incarceration. So
glad you made it.
We are asking for Mr. Goulsby to be released.
Anything else from the state?
Oh, good to know. Thank you, Brian.
No, Your Honor, thank you.
He said a lot. And in case people are wondering why I didn't thank him for his service, he was discharged. He didn't finish. He probably, for sounding like this guy, he may have gotten into some trouble.
This is the court's ruling on the state's motion seeking pretrial detention in this matter. All findings and legal basis for same are made pursuant to NJS 2A:162-15 through 26. Pursuant to statute, the court has had the opportunity to review defendant's biographical information, his personal history and characteristics. He is 23 years of age at the time of the current arrest. It is
he looks a lot older.
To be a current violent offense. The defendant, however, has residence and ties to the community, including family. He is presently unemployed, although looking for a job. Defense articulated in their arguments that he's struggling with substance abuse, possible alcoholism that appears to be untreated.
She's really good.
And in reviewing his past character, he formerly served in the armed forces, but had a discharge again due to substance abuse related issues.
There it is. There it is. He was using cestices. Can't have that in our military. No, sirree, Bob. We got the good shit over here. That's the top notch.
Court has reviewed the PSA's determinations, and I will note once again that the PSA's recommendations are not dispositive and only one factor among others to be considered from the court. From the PSA, the court finds the defendant is presently not on probation. However, he is presently on level 2 pretrial monitoring, pretrial release here in Atlantic County. He's not on parole. There do not appear to be any pending trials or sentencings. There's no warrants or detainers active. PSA scores Mr. Goulsby at a 2 for failure to appear and a 3 for new criminal activity, which are on the lower end of both scales, where 1 is the lowest, 6 is the highest. As recommended on the PSA, there is a no release recommended due to repeated arrests while on pretrial release. Even so, the court having reviewed the nature of the current charges, I must note that the presumption here, based upon the severity of the charges, 3rd degree and disorderly persons, that the presumption is against detention, and the state bears the burden to prove by clear and convincing evidence, as required by statute, that detention is warranted in this matter. The court having reviewed the nature and circumstances of the current charges, again, it's a 3rd degree, it's a violent charge, aggravated assault, which is a concern. However, the other charges of disorderly persons, theft of services, again, allegation that he drank a beer that he didn't pay for at a casino. I don't see any additional enhancements other than the
How did he get his hands on the beer?
And the court will consider this matter and the nature
Drinking
and
a beer.
circumstances of this case under the triad outlined at NJS 2A:162-20. That is, the risk the defendant will fail to appear to future court proceeding, the nature and seriousness of the danger the defendant poses to a particular victim, the community at large, or any other person should he be released, and the nature and seriousness of the risk the defendant will obstruct the criminal justice process going forward. I'll start with prong 1. Again, none of these charges are in the 1st or 2nd degree range. There are no failures to appear by this defendant at a court appearance within the last 2 years or predating that 2-year period. It is noted that he does have out-of-state contact due to offense in the state of Tennessee in March of 2025, so a year ago. I do find that to be significant. However, on balance, considering his ties to the community and his presence within Atlantic County, I do find that his risk of failing to appear is low under prong 1. So I assign it low weight. Moving forward to the nature and seriousness of the danger, again, there is 1 current violent charge. The defendant carries with him the presumption of innocence with regards to that current charge, as he does with his 3 pending charges, which none are specifically violent charge, although 2 are domestic violence related. Again, a burglary apparently and allegedly involving a girlfriend or a prior girlfriend. However, the defendant does not have any prior indictable convictions, prior disorderly persons convictions, no juvenile adjudications, no prior violent convictions of any kind. There is the allegation here of spitting on law enforcement officers after his arrest. However, no specific injury is noted or any treatment of the alleged victims, including the earlier behavior alleged in the casino. Additionally, the court finds the defendant has 1 prior domestic violence restraining order. It was dismissed. However, it was relatively recent, from January of this year. In reviewing the alleged behavior, it is alleged to have occurred in a public marketplace at a casino. The court is familiar with the effects that
we're all thinking he's going to get let loose
of this nature have not only on the hospitality industry, the people who work within the casinos, but also on guests and the public to these places. So I do find that there is a danger of this type of behavior to the public at large.
Okay.
As such, in reviewing all of those factors under prong 2, I assign substantial, but not great weight. Moving forward to prong 3 of the triad, the defendant does not have any resisting, obstructing, hindering previous arrests for being uncooperative, at least within the state of New Jersey. Again, the unclassifiable charge out of Tennessee from March of 2025 alleges fleeing. So the court does consider that, along with the alleged uncooperative behavior when confronted by law enforcement within the casino. in addition to the allegations of consuming alcohol in violation of the terms of pretrial monitoring level 2 that was in place at the time of the current arrest. Defendant also has those 3 pending charges. However, there are no pending specific violent charges, although 2 are noted to be domestic violence in nature. Furthermore, the court, in reviewing prong 3, will note the defendant does not have any prior sentences to incarceration of any kind. As such, I assign the weight of prong 3 substantial weight, but not great weight. Moving forward to the weight of the evidence in this case, I do find it to be strong. There are alleged admissions by the defendant to the alleged behavior. There are witness statements, in addition to law enforcement observations, body-worn camera footage, as well as casino surveillance footage, as well as physical evidence. Again, the can or bottle of beer. So I do find the weight of the evidence in this case to have great weight. All told, based upon the court's review of the totality of the circumstances, including the review of defendant's criminal history, the recommendations contained within the PSA, which the court gives due consideration to, and the facts and circumstances of this case, the court finds the state has not met its burden in showing that there's no amount of monetary bail, non-monetary bail conditions of pretrial release, or a combination of monetary bail and conditions that would reasonably assure the defendant will appear in court as required, assure the safety of the victims and the community at large, or the defendant will not obstruct the criminal justice process going forward. Therefore, detention is denied, and the defendant will be released. However, given the totality of the circumstances, the defendant will be released on level 3 level of monitoring, and in compliance with NJS 2A:162-23, subject to the following least restrictive conditions that the court finds necessary to ensure his appearance in court and safety of the community at large. Now, Mr. Goulsby, I'm going to order you released subject to the following non-monetary conditions. That means I'm not requiring any bail in this case. You must appear, though, for all scheduled court proceedings. You must immediately notify pretrial services.
He's not even going to have to pay any kind of bail. Leather and Lashes with $2 in bail money. L and L, it's always a pleasure to see you. Hope you're doing well. I'm not surprised, guys. I mean, he was dealing with a few things already coming into this, but it seems like, you know, the judge was very thorough. I like this judge. He's real thorough. He really ran through everything, letting us know what weighed what and where it went and everything else. I mean, he's going to get outs. Gots to go. I'm going to give him bail. That's New Jersey law as of 2027. Oh, okay. So go ahead and finish listening to the judge read this out.
Of any change in your address, your telephone number, or other contact information. You're not to commit any offenses during the period of release. Again, you're to avoid all contact with any of the alleged victims of these offenses. Additionally, sir,
no casino.
With regards to restrictions on travel,
good to know.
I'm going to indicate here that you're restricted and you are to comply with all recommended treatments stemming from those evaluations.
He's going to try and get him some help.
Now, these evaluations are not optional. They're conditions of your release. So failure to comply with them would be a violation of the terms of your release.
I mean, he's obviously got problems with substances and alcohol. I mean, got him kicked out of the military.
Reasons for a departure from the pretrial services recommendation are due to other relevant evidence presented to the court. Sir, you must notify the court immediately in writing if you're detained in jail or in prison or otherwise cannot appear at a future court proceeding. If you fail to appear at a future court proceeding and you are arrested in another state or jurisdiction, you agree to waive all rights to extradition proceedings under New Jersey statutes and the demanding state or jurisdiction statutes with regard to extradition law. Now, if you fail to appear, you violate any of these conditions of pretrial release, or you obtain a new restraining order, you commit a new crime, it may result in the following penalties and consequences. You may have a warrant issued for your arrest. You could have your release revoked. You could be detained once again. You could be imposed increasingly restrictive conditions, or you could forfeit any monetary bail posted against her. I'm not ordering it at this time. Additionally, counsel, with regards to violation of monitoring, anything further?
Nothing from us, Judge.
No, Your Honor.
I do find, based upon defendant picking up new charges, as well as the allegations of consuming alcohol, that the defendant did violate the terms of his previously ordered pretrial monitoring release level 2 that was put into place on the 13th of January 2026 by Judge McGuire. As a result of the violation of pretrial monitoring, the court finds here that amendment to defendant's pretrial release conditions under ATL 26-186-001 is appropriate at this time. The amendment is, again, that he will be released on pretrial monitoring level 3 conditions. This matter is to return to court on the 15th of April, 2026 before myself, Judge Coombs. Anything else from the parties at this time?
No, Your Honor, thank you.
Well, that's that. A lot of fun there. If you guys enjoy these New Jersey cases, they are stacked every day. We could watch these till cows come home. But if you guys enjoy that kind of stuff and think that that's something we need to start doing again, I'm tinkering around trying to figure out where I want to do some live court. I want to get live court back into the rotation. Maybe at night, maybe not late night, but maybe nighttime. Start doing some court like this. I really enjoy doing this kind of thing and watching court with you guys. I try to do a little something during the day because I know a lot of people are stuck at home or whatever, and they want to do it and check it out. Late night licking would be fun. I was going to do a Chase Extra. I might have time to knock it out. We'll see. Yeah, it's a lot of fun. This is Middleton's last year. It's gonna be his last year. Judge Boyd, I think, is till January. So this is her last year. So yeah. If you're new here, do me a huge favor. Hit the like, do all that kind of stuff, because that lets me know, hey, we're doing something right over here, and lets YouTube know more than that. That hey, something's going on. Leaving comments, hyping videos, all those things are instrumental in helping channels like ours that are run by Americans here in the United States that are trying to fight the AI that's coming from overseas and taking over. We'd really, really, really appreciate you helping us out. All the creators, not just me, all the creators, all the OG creators of the court area here that have been working so hard for so many years. We don't want to see it basically taken over and salvaged and scavenged, or whatever you want to call it. It'd be rough. Bobzilla, thank you, Mr. Bobzilla. Chaos AD, Mr. Michaud, Bobzilla, head, Mr. Michaud again, Bobzilla, Chaos AD, huge gifts. Mr. Michaud right behind him with them big gifts as well. Don, I'm going to go check that PP. Thank you. Leather and Lashes, thank you for all the birthday wishes. If I don't see you before 4:05, it's gonna be cutting it tight on time. I will see you at 4:05, and don't forget, members only on the main channel. Credence and Mikey, there's a new intro. Look at that. Sending over monies right here at the ends. Let me knock that off and thank you guys. Don't forget, we got the box opening today. We're going to watch their members. And we're also going to be, I need to clean out the computer and get rid of some of these news stories I've been holding on to. So a stacked up card of news stories. Get your nap in. Thank you so much. Also, speaking of channels you got to watch out for right here, courtroom files. Make sure you go there. We've got to keep the home fires burning for the OG court channels, for all the channels that are here that have faces and names behind them, trying to keep it going. It's only going to happen if you guys support the right channels, not the ones that are just pillaging the purses of the others. We need all those to stick together. Thank you. And I'm sure you guys know who Courtroom Files is. So make sure you go over there and check out some of the awesome stuff they do as well. All right. All right. I like it. We all like it. Damn it. We're getting the hell out of here. I love you guys. Stay safe, stay hard, stay tuned. I'm Mikey the Legend. You're not. I'm going to say bye for now. Y'all remember that time? Oh, wow. I can kind of see myself. Y'all remember that time I was WCW champion? True story.